Yes, thank you very much. I'd like to first take this opportunity to give thanks to Dr. Yang Mi-gang, Dr. Kang Sung-ho, Professor Lee Jang-hee, Professor Delancey, and other members of the History NGO Forum for giving me this opportunity to speak about a very important topic, sexual violence and human rights of women. For me to speak as the first presenter in this four-part series lecture webinar. And I'd also like to thank all the other participants for taking part in today's event. Good. So as Professor Lee just kindly introduced, I will be speaking on the topic of the current status of the Japanese military comfort women issue and the crux of the problem. This obviously will be mainly presented from the South Korean perspective. This doesn't mean that I do not mean to exclude victims from other countries like the Philippines, Taiwan, China, from the Asia Pacific region. As you may have heard over the news lately, there have been a couple very important and contradicting decisions in the lawsuits brought by South Korean comfort women survivors against the Japanese state in South Korean courts this year. No less importantly, Lee Young-soo, who is one of the survivors of the comfort women system, has publicly asked the governments of South Korea and Japan to consider referring the comfort women issue to the International Court of Justice, which is the principal judicial organ of the United Nations. Before getting into these details or the recent developments, however, I first want to provide you with the historical background that set the stage for these historic lawsuits, including the Korean-Japanese bilateral relationship and the broader comfort women redress movement, especially in comparison with other redress movements, namely the Holocaust Jewish victims and also the Japanese American internment survivors. I do want to emphasize at the outset that the comfort women redress movement had to resort to legal actions in the South Korean courts and call for international justice judicial process, precisely because it was not possible to reach a political settlement before going to the courts. In other words, the victims really had no other choice. Lastly, I also want to discuss what needs to be done going forward, namely how to translate the legal actions currently taking place in South Korea into concrete realization of the demands that the comfort women survivors have been making for the past 3 decades. It would be an understatement, really, to say that the South Korean-Japanese relationship has been historically complicated or tense. It is nothing short of a miracle that Korea has an independent existence surrounded by great powers such as China, Japan, and Russia. Naturally, this is a source of great national pride for the Korean people. And conversely, Japan's 35-year of colonial rule, very harsh, cruel rule over Korea, or 40 years if you count the period coming from the Russo-Japanese War which began in 1904, is not something that the Korean people can forget easily. Especially from the late 1930s to the end of the Second World War, Japan mobilized millions of colonial Koreans and also Taiwanese people into the execution of its aggressive war against the other Asian states. Most of this mobilization took place through the Japanese law called the National Mobilization Law, and it obviously left behind many victims in its track. Also importantly, for today's discussion, the Japanese also created the comfort women system for its military, which actually had no statutory basis. Obviously, no self-respecting country would legalize state-organized mass human trafficking or sexual slavery. But Japan created this comfort women system anyway, without such a legal basis. After the end of World War II, Korea regained independence, but it was divided into the Soviet-backed Communist North and the US-supported anti-Communist South. And the two sides waged a 3-year bloody war that resulted in the deaths of many millions. As luck would have it, Japan actually retained its territorial integrity, although it lost its overseas and colonial empire. And post-war Japan conveniently became a pacifist nation, profiting from the Korean War and the Vietnam War without the burdensome military expenditure or expending its human lives. South Korea, therefore, had to negotiate normalization relationship with Japan from a rather weak bargaining position and actually swallow its national pride. The negotiations took 14 years, which by itself shows how difficult the talks were. And South Korea eventually had to compromise, for example, on affirming the illegality of Japan's annexation of Korea, that the Korean people considered illegitimate and illegal. South Korea also signed a claims agreement with Japan that quote unquote settled completely and finally the property claims existing between the two nations. Now, what this complete and final settlement really means in practice, also in law, has been a source of dispute in both countries for many years. South Korea was under military rule at the time, and the government chose to use the large bulk of this money for the economic development, for projects such as the construction of the national highway and also the steel corporation, which enabled South Korea's economic rise. Obviously, this was not the policy preference of the World War II or colonial era victims, but because they were under military rule, they really didn't have much say for many decades. In 1987, South Korea was finally democratized with the return of the direct election of the presidents. This meant that the wartime victims could now freely express their opinions and views about the reparations, and also, importantly, to file lawsuits in court without fear of retribution from the state. It's actually a common misconception to think that it was only in 1991 that the first comfort women, Ms. Kim Hak-soon, came forward with her wartime experience as a sexual slave. In fact, the Japanese journalist named Sanda Kako had written a book entitled Military Comfort Women already back in 1973. And the Japanese media had actually published interviews with Korean comfort women who had settled in Okinawa after the war, named Bae Won-gi, as early as 1975. The problem was not that the people did not know about the existence of the military sexual slavery system, but the fact that people did not recognize such system as a war crime or crimes against humanity. So the right question to ask when it comes to the comfort women redress movement is not to ask why such a movement did not exist before the 1990s, but rather why such movement began to rise since the 1990s. Now, there were several historical factors that enabled the launch of this comfort women redress movement. The collapse of the Berlin Wall and the larger communist bloc, which ended the Cold War pretty much overnight, removed the existential threat of nuclear Armageddon. And the so-called third wave of democratization, which included not only South Korea, but also Taiwan, the Philippines, and other East Asian countries, paved way for this kind of talk about human rights optimism in the post-Cold War period. It's also important to note that in the 1990s, the people belatedly took interest and began to take stock of the experience from World War II, which kind of had been foreclosed during the decades of the Cold War. You can see like popular movies like Schindler's List, Saving Private Ryan, or Band of Brothers that were set in the World War II period and the Holocaust experience. The heightened interest in human rights in general, as well as women's rights in particular, manifested itself in calls for the protection of women from sexual violence and other gender-related crimes. This became a very current issue because of the Bosnian conflict and the Rwandan genocide, which took place in the 1990s. Also in 1995, the Fourth World Conference on Women was held in Beijing, where the women's rights activists, including the Call for Women Redress supporters, had a chance to speak up about their issues. Even in Japan, there were some favorable developments. In 1989, Emperor Hirohito, considered by many to be a war criminal who had escaped justice, probably rightly so, died in 1989. And in 1992, historian Professor Yoshimi Yoshiaki made public, including documents from the Japanese Defense Ministry archive, that removed any doubts about the Japanese government's involvement in the creation and operation of the World War II era military sexual slavery. Also, no less importantly, the conservative Liberal Democratic Party, which had ruled Japan without interruption for 38 years, finally lost power in 1993. So it was all of this seemed to portend a new wind, even within Japan. And at the UN, at the UN Commission on Human Rights, Japanese human rights lawyer Totsuka Etsuro actually made a statement about the Comfort Women issue as early as February 1992. And in 1996, the UN Special Rapporteur on Violence Against Women, Ms. Radhika Kumaraswamy, released a report on the issue, on the Comfort Women issue, based on her visits to Japan, South Korea, and North Korea. 2 years later, in 1998, the UN Special Rapporteur on Systematic Rape, Sexual Slavery, and slavery practices during armed conflict set out a comprehensive legal analysis of the Comfort Women system with concrete recommendations directed toward the Japanese government and other relevant parties in a report. This basically formed the background for other developments, such as the Security Council Resolution 1325 that Dr. Yang mentioned concerning women, peace, and security in 2000. So all seemed to go well at first, but that was not to be. In Japan, in 1994, just less than a year after the LDP's loss of power, it was back in government again by forming a coalition with the Socialist Party, whose leader, Murayama Tomiichi, became the Prime Minister of Japan. Unfortunately, Murayama, he probably meant well as a socialist Prime Minister, but he was frankly not so competent, and he failed to take a strong stance on the Comfort Women issue against the more conservative LDP or the Japanese bureaucracy. The Foreign Ministry, or Gaimusho, as it is called in Japanese, in particular opposed the state compensation because of its long-standing position that all such claims had been.
외무부에서 강력하게 반대를 했습니다. 그러면서 그 한일 기본 조약을 통해서 이런 모든 배보상에 대한 권리가 다 상실되었다라고 주장을 했습니다. 그리고 위안부 피해자들을 위해서 아시아 여성기금이라는 것을 창설하는 그런 운동이 있었습니다. 그래서 한국과 대만 등의 피해자들을 대상으로 한 것이었는데요. 그리고 또 우익에서 공격이 이어졌습니다. 예를 들어서 오크노 등에 의해서 위안부 문제를 전면적으로 부인하는 이런 망언들이 이어졌습니다. 특히 1995년에 이 평화 결의안 50주년 그 선언이 제2차 대전 종식 50주년을 기념하는 그 평화 결의안이 대실패로 돌아갔고요. 그리고 2000년 4월에 일본 총리 오부치가 심장마비로 사망을 했습니다. 오부치는 역사 문제에 대해서 좀 열린 시각을 가지고 있었고, 그리고 21세기 한일 신동반자 공동선언을 98년에 김대중 대통령과 같이 발표하는 등 좀 열린 시각을 가지고 있었는데, 그리고 또 관방장관도 당시 이제 연대의 시각을 가지고 있었고요. 그리고 또 일본에서 있었던 그 불합민 운동도 긍정적인 영향을 미쳤었습니다. 그리고 또 이렇게 그 다른 그 전쟁 피해자들에 대해서 좀 연대하는 그런 시각을 가지고 있었습니다. 하지만 그리고 또 일본에 거주하고 있는 그 한인에 대해서 배상을 하는 그런 법안이 2000년에 통과되기도 했었습니다. 그 이후에 이제 계속해서 우익 총리들이 등장을 했죠. 요시로와 주니치로, 신조, 타로 등이 들어서면서
Now, in 1998, there was a historic decision from the Shimonoseki District Court in Japan, which was actually the only decision where, among the 10 lawsuits brought by the comfort women victims, where the victims actually won. And this was actually a missed opportunity in the sense that the opposition parties in the national diet failed to bring a compensation legislation immediately after the judgment. It actually took them 2 years to prepare legislation, and this was actually would never be enacted in the Japanese diet. Also, rather unfortunately, there would be similar court decisions in other countries, such as the Netherlands and also in the United Kingdom, about past colonial era atrocities. But these decisions would come all come after 2011, many years after the Shimonoseki decision. So it basically came too late to influence the developments in Japan. So basically, so that was the court decision. The court cases and for the comfort women did not go so well in Japan. No less importantly, the victim states such as South Korea, China, and other countries in Southeast Asia had political and economic reasons for not speaking up on behalf of the comfort women victims against the Japanese government. Also in the United States, following the success of the Nazi-era Holocaust restitution in the 1990s, there was a general consensus that Japan should also pay up for its wartime atrocities. So this movement was also backed by the U.S. prisoners of war during World War II, and the state of California actually passed a law in 1999 that extended the statute of limitations for the victims of forced labor up to 2010. And the US Congress also came very close to passing a law that would allow the US POWs to sue the Japanese government and businesses in spite of the San Francisco Peace Treaty. Around this time in 2000, 15 comfort women victims from South Korea, Taiwan, the Philippines, and China sued the Japanese state in US courts. Unfortunately, in 2000, George W. Bush defeated Al Gore in a controversial election and became the next president, which kind of put an end to the Clinton era policies concerning the World War II era reparations. And a year later, in the 9/11 terror attack, resulted in Bush's persecution of the war on terror. And all this also meant that Japan would become an important ally in this new war on terror. So that kind of led to the loss of momentum for the judicial and legislative efforts. It's interesting to compare the Comfort Women Redress movement with, for example, the Jewish reparation after World War II. In 1943 and 44, even before the end of World War II, the Jewish scholars Moses and Feinberg actually had a debate about how to present the Jewish claims against Germany after the war. And the winning argument made by Siegfried Moses was that since existing international law provided limited grounds for reparations, the Jews should emphasize political action over legal actions to realize their claims. This is actually precisely the course of action that the Jewish groups and the State of Israel took after 1945. And it resulted, first of all, firstly in the 1952 Luxembourg agreements between the State of Israel and the Jewish Claims Conference that represented the Jewish survivors of Nazi persecution living outside of Israel, and the German state on the other side. And this became the model for the later settlements between the Jewish victims and the German government and German businesses, all the way up to the 2000 agreement to create the Foundation on Remembrance, Responsibility, and Future to compensate the slave and forced labor victims. So while the Jewish victims did use litigations to pressure, especially the German businesses, they largely supported, the lawsuits largely supported this kind of political settlement rather than replacing them. They in fact almost never won a single legal case against German businesses, even in the US courts. Similarly, the Japanese internment victims during the World War II pursued mostly legislative remedies in the U.S. courts, U.S. Congress. And although a splinter group did file a lawsuit against the U.S. Federal government for compensation, this was actually dismissed by the courts, although it did help convince some members of Congress to vote for the compensation bill. So in a sense, the Comfort Women Redress movement had to resort to legal actions in South Korea, largely because the political settlement failed to materialize. Also, the courts in post-democratization South Korea were relatively hospitable to such claims. The newly created constitutional court's reason of existence was basically to protect the basic rights of the people. There were also a series of court decisions that ordered the South Korean government to make compensation, not only for the authoritarian abuses in the 1960s, 70s, and 80s, but also for the massacres of civilians before and during the Korean War, going back to 1949 or 1947. So the judges, South Korean judges, saw no reason why the Japanese government or Japanese businesses should be exempt from the legal liability for what they did in the early 1940s. The South Korean courts also rejected the legality of Japan's colonial rule over South Korea on the basis of the South Korean constitution. In 2011, the Constitutional Court unexpectedly ruled that South Korea's failure to arbitrate the claims of the Comfort Women survivors under the 1965 Claims Agreement was unconstitutional. This led to South Korea officially raising claims on behalf of the Comfort Women to Japan. The resulting negotiations ended up in the 2015 agreement, a very controversial accord, where Japan recognized the government's responsibility and offered a 10 billion fund from the Japanese government budget to be paid out to the victims. However, the deal was rejected by the South Korean victims who were not fully informed about the details of the agreement. And it represented a failure, a continuing failure to translate this kind of legal actions into concrete political settlements for the victims. The Comfort Women victims actually challenged the 2015 accord between the two governments in the Constitutional Court. The Constitutional Court rejected the suit in 2019 on the ground that the 2015 accord is merely a political declaration without any legal effect. The court's decision at the same time explicitly denied the legal binding nature of the 2015 agreement. Now, earlier this year, the South Korean district courts issued decisions on two cases brought by Comfort Women survivors against the Japanese government in South Korean courts. The main question in both cases actually was whether Japan enjoyed jurisdictional immunity or sovereign immunity that foreign governments are usually entitled to when they are sued in domestic courts. Of course, this issue had broader ramifications than just the Comfort Women cases. Obviously, it would have impacts on other human rights violations, including sexual violence and other grave violations against women's human rights. The most interesting points in this debate was, as I said, whether Japan could enjoy immunity for grave human rights violations, and whether the right to trial for the victims of such grave violations who do not have alternative remedies should supersede the doctrine of this kind of sovereign immunity. In the first judgment of January 8, the South Korean court held that Japan could not enjoy immunity for sovereign acts amounting to crimes against humanity in violation of jus cogens norms or peremptory norms. Obviously meant that grave human rights violations could not be subjects for such immunity in domestic courts. Now, the court ordered Japan to compensate the victims, but Japan actually refused to respect the ruling and actually claimed that the South Korean court's judgment violated the doctrine of its sovereign immunity under international law, and threatened for a moment to sue the South Korean government in the International Court of Justice. In the second judgment made on April 21st, the court reached the exact opposite conclusion. It actually held that Japan is entitled to such immunity under the positive law or the existing law in the international norms. It basically also stated that the enforcement of sovereign immunity, even for such grave human rights violations, was permissible was a permissible restriction on the right to trial guaranteed by the South Korean Constitution and also international human rights law. Obviously, the victims were horrified by this decision, and they have appealed it to the High Court, and the case is currently pending. So it's interesting to note that although the first and second court judgments reached diametrically opposite conclusions about the applicability of whether to allow lawsuits against the Japanese government, both cases are basically still up in the air, in the sense that the first judgment has not been enforced by the Japanese government, and it will be very difficult for the South Korean victims to enforce them. And the second case will probably end up all the way to the Supreme Court, unless the High Court rules in the victim's favor. In the midst of all this, Lee Young-soo, who is one of the surviving members of the Comfort Women system, made a public call to the governments of South Korea and Japan to refer the Comfort Women issues to the International Court of Justice on February 16th. She specifically asked that the two governments should ask the court to consider whether the Comfort Women system violated international law, also whether what would be the legal consequences if the comfort women system indeed violate international law. Thirdly, also whether the post-war treaties had invalidated claims against claims of the comfort women against Japan, and also whether the January 8th decision, which made exceptions to the immunity enjoyed by Japan in domestic courts, was legal under international law. So the ICJ referral, and I want to say as a disclaimer that I'm not a neutral party in this debate because I am advising Ms. Leong-soo on this matter, and I am actually trying to convince my government and also the Japanese government to get on board with the ICJ plan. Having said that, the ICJ referrals, the pros would be that the ICJ can issue legally binding and authoritative decisions as the UN's principal judicial organ, and it has full-time judges and fixed procedure. And it can order various remedies, not only financial compensation, but it can also order Japan to admit to its wrongdoings and also to issue official apology. Also importantly, the ICJ proceedings will leave behind court records as the Nuremberg and Tokyo tribunals did after the end of World War II, as an effective means to combat denial of the comfort women history, as Professor Ramsier very recently showed. The cons or the downsides of bringing a case before ICJ was that the arguments made were that there are no clear supporting voices from other surviving victims, and it's also essential that not only South Korea but Japan must also agree to the referral to the ICJ. And for many South Koreans, the issue of Dokdo Island, which basically South Korea has had an effective rule for over the past 70 years, but is still claimed by Japan as their own, is a very sensitive issue. And there is a fear that if the comfort women issue is brought to the ICJ, then Japan will actually make a counterclaim to bring the Dokdo issue to the ICJ as well. There are also that the ICJ proceedings would actually worsen the Seoul-Tokyo relationship. So these were the kind of arguments made against the ICJ proposition. Another international judicial process that the victims could resort to would be the international arbitration. In 1994, actually, the comfort women victims they did make this proposal to Japan to bring their case before the Permanent Court of Arbitration, which actually Professor Lee Jang-hee, as you've heard, is also a member of. Unfortunately, the Japanese government rejected this proposal. Interestingly, also the 1965 Claims Agreement, as I mentioned earlier, contains an arbitral clause. So another possibility would be to resort to this clause to bring cases before international arbitration. Another interesting possibility would be to cite the 1984 UN Torture Convention. I think there are ample arguments to be made that the comfort women system falls under the rubric of torture as defined by the Torture Convention. And the Torture Convention actually provides for both interstate complaints to be made to the Committee Against Torture, and also to bring cases to international arbitration or to the ICJ for its legal judicial settlement. Unfortunately, again, the downside of this proposal is that it's not clear if the Torture Convention, which was concluded in 1984, can have retroactive effect to events that happened during World War II, which, as you know, happened like 4 decades before. So going forward, I guess the real question would be how to realize the 7 key demands that have been made by the comfort women themselves for the past 33 decades, namely the admission by Japan of its war crime and fact-finding, official apology, and legal reparations, and the punishment of the perpetrators, as well as for the History NGO Forum's context, importantly, the inclusion of reference to the comfort women issue in the history textbooks, and also memorials and archival facilities for the comfort women system. it would be really challenged to find a viable way to realize these demands before the remaining survivors pass away. So although the legal actions thus far have had some progress in South Korean courts, obviously that is unlikely to be the ultimate solution to the issue. But it is definitely something that needs to be used strategically to raise publicity and also to put pressure on the Japanese government. But I guess the things that needs to be done include the need to articulate the 7 demands that I just mentioned in greater detail for reference for future negotiations with the Japanese government. And also to utilize the other various forums that I mentioned, including both international and domestic forums. In terms of national forums, there, as I said, have been unsuccessful lawsuits in Japan, the US, and the Philippines. And obviously these are not have had rather mixed results, but it would be important to refer to the more recent cases, for example, as I mentioned, in the UK and the Dutch courts, and also other Holocaust-related cases in European courts, to make a stronger case for the confirmed redress. So this is a very brief. This was a very brief overview of the efforts made for the reparation on behalf of the confirmed women system, confirmed victims, and I hope this helped you provide a very general picture of the kind of 30-year-long redress movement that the survivors and their supporters have taken on since the 1990s. Thank you.